Peace, peace, peace. Good to have you back. I'm Juice Warner. This is Old Your Gritty Grand Strains. We are reading once again, right? Keys to Masonry, right? Kindred Secrets Combined. We're up to chapter 3. Please do not hesitate to hit that like, that subscribe, and that notification bell so you can be notified whenever new content is being uploaded or we go live, just like now, which is mostly all the time. We always go live like most of these shows because, like, I don't know what it is. It's on my camera. I'm trying to figure out why I be like jittery when I do pre-recorded shows. So until then, I mean, there's sometimes I do a pre-recorded show, but until then. But anyway, this right here is Old Your Gritty Mug. On one side it says Old Your Gritty. On the other side it says I Gritty New York. Right? We have this along with my personal novel, Street Scuzzy, Knock 'em Out the Box. As you can see, it's a nice full book, right? As you can see, right? Over 400 pages. It's a murder mystery about two brothers who must team up, but they're on opposite sides of the law. But they must team up in order to find their father's killer or killers. It'll take you through the city of New York as well as the tri-state area. Please pick up your book. It's a great read. But like I said, most importantly, to help me with my algorithms and stuff like that, hey, hit the like button, hit the subscribe button. Hey, you know what? Also, comment, and share. All of that right there helps the algorithm. As far as I know, that's how it works. Right? So let's get into chapter 3. Oh, wait. Matter of fact, let me put that inside my ticker here. All right. I forgot to change the title inside there. Okay. Chapter 3. Let's go, fellas. Okay. So, it's the Ford trial. Very important. Startling statements of Griffin, a Sir Knight who acted as lawyer on behalf of the Morgan murderers. Right? So, as we know, this is, anti-Masons are telling you what levels they would go to keep the secret, right? The testimony of the following witness to the character and doing of Masonry is, if possible, still more startling and it must be accepted by the fraternity, for it is Masonic testimony. Calvin Cook was a miller and a succeeding Mason. Harvey Cook was an adhering Mason of high order and had an interest in that part of the mill where the plaster was ground. But now in the grain grinding department, Harvey Cook, agreeably a Masonic obligation, used his most decided endeavors to bring his offering cousin to the strictest and most condign punishment. To that end, he repeatedly broke the door and machinery of poor Calvin's mill and was more than once caught in the act. Yet he persisted and even told Calvin that if he did not succeed back from the anti-Masons, he should not wonder if his house would burn down over his head. Meantime, the conspirators published and circulated the vilest slander concerning poor Calvin, especially in the Masonic paper called The Cabbage Leaf. At length, Calvin Cook sought justice in the civil suit against Harvey before Benjamin Copeland, Esquire, in the town of Fort Anne. Hence, the case has been known as the Fort Anne trial. The document from which I quote is bound up to the Anti-Masonic Almanac for 1831 and is quoted from the Albany Evening Journal, which reported that proceedings in the case, the importance of the information will justify our giving somewhat lengthy quotations. A jury was called in the offering, having the veneer to serve, aware of the excitement and wishing to avoid all imputations of blame and partiality, summoned the jury, a part of whom were Masons and a part anti-Masons. E.D. Culver was counsel of the plaintiff, and Henry Thorne, Esquire, was defendant. On calling and impaling the jury, Erictus Day, one of the jurors called us challenged by the plaintiff's counsel for favor on the ground of his being a member of the Masonic institution, being charged in the challenge with being. Is that supposed to be a 4 there? I don't know what that 4 is for. It's like see that 4 right there? Right. See, because you look at 50 right there, so I don't know. Under obligation to obey signs, summons, and tokens of the brother Mason, being sworn to aid and assist and to execute from difficulty and companion Royal Arch Masons, right or wrong, and being sworn to answer the grand held sign of distress. Right, and company. The challenge was reduced by writing and demurred to by the defending counsel, and demurrer was overruled by the court, who thereupon proceeded to appoint Hiram Shipman and Perium Thomas Tears, Hiram, right? Arius, Erestius Day was then sworn witness on the part of the plaintiff. On being asked if he was a Mason, he refused to answer and promptly told the court and the counsel that they would not be able to get anything out of him about Masonry. The court decided the question was a proper one and that the witness must answer it. He then reluctantly swore that he was a Mason, that he had taken 17 degrees, did not remember where he was made a Royal Arch Mason, had sat frequently in the Glen Falls chapter. He was then asked if he had taken the usual oath or obligation from the entered apprentice to the Royal Arch. He refused to answer. The court said he must, but he still refused. Said he considered his Masonic obligations binding and would not violate them for any court, right? So right here. It goes. It goes. He was reluctant and swore that he was a Mason and that he had taken 17 degrees and did not remember. He sat frequently in Glenn chapter. Right? It goes. He was asked then if he had taken the usual oaths and or obligations from Entered Apprentice to Royal Arts degree, right? And that's what he refused to answer that, you know. So hold on a minute here, right? Chapter, um, right? So you see that right there. It goes. Let's see. Right. So basically, he was asked. He was then asked if he had taken the usual oath or obligations from the Entered Apprentice to the Royal Arch. Right? Said he considered his Masonic obligations binding and would not violate them for any court. So that question is a very vital question. He was asked relative to obeying the signs, summons, and tokens, so relative to flying to the relief of a person giving grand hailing signs of distress, but refused to answer, although told repeatedly by the court that the questions were proper and pertinent, and that he was bound to answer them. He was then asked relative to the clause in the Royal Arch Oath of aiding and assisting in executing a companion from difficulty, right or wrong. He refused to answer. He said he could not without, well, I guess it's supposed to be incriminating himself. When asked relative to being under oath, he kept the secret of a brother, murder and treason not accepted. He refused to answer and at length told the court that he considered his Masonic oath superior to the oath he had taken before the court. It will be seen, of course, that these Masonic witnesses demonstrated two things, namely, first, that Masonic oaths have been truthfully divulged by succeeding Masons. Second, that these oaths set a defiance the whole of the divine moral code, as well as all the laws of the church and state. But we proceed with this remarkable trial. Silvius Cone was next called as a witness. He refused to be sworn, saying to the counsel of the plaintiff, "You ain't Agan ain't gone." I'm sorry. I wasn't expecting this. This was funny right there. He's the plaintiff. "You ain't going to get me into trap Mr. Day was in. That is swear to tell the truth and then find that to do so would be to violate the Masonic oaths previously taken. You don't catch me so. The court and his friend advised him to be sworn, and when reminded of the plaintiff, he at least consented, and then swore in the presence of Almighty God that he would true answer make as such question as should be put to him touching the challenge in question. He was then asked whether there were certain oaths or obligations administered to persons passing through the different degrees of masonry, but he refused to answer. Notwithstanding, he had just sworn to make true answer. The court decided that he must answer, but he replied that the court could not extort the secret of masonry from him. Dr. Bush, a member of the fraternity, then told the witness he could give negative answers and not reveal anything. Dr. Bush, a member of the fraternity, then told the witness he could give negative answers and not reveal anything. A question was then put which could easily be answered in a negative if the clause of Master Masonry degree clause in the master's degree relative to keeping secrets in company were not as it was then quoted to him word for word, but to the question he refused to get it to give even a negative answer. He was then asked relative to the sign of distress, helping out of difficulty in company, all which questions he refused to answer, though he told by the court that they were proper and permanent. Pretentement. Pretendant. When asked relatives to the Masonic privileges of the plaintiff and the defendant, he said he was under the same moral obligation to the one as to the other. The question was repeated. Are you under the same Masonic obligation to the one as the other? Him. I am under the same moral obligation. The question was repeated, but no answer given. Thus, the poor oath-bound slave was as fast in the trap as his oath-bound predecessor, for he openly violated his civil oath and yet gained nothing either for himself or masonry, for his refusal proved all that was claimed. Moreover, while he acknowledged that the moral law laid him under equal obligation to plaintiff and defendant, he set that law at defiance by his attempt to adhere to Masonic law, and so must everyone who makes the same attempt. Alicia M. Forbes was called for a witness. When sworn, he said, I thought his name was Lisa, said that the court, now I'll tell you anything that isn't masonry, but anything that is, I won't. Several questions were accordingly put, which were not calculated to broader on the secret of masonry. He answered them promptly. He was then asked, direct relative to the clause of keeping all the secrets, helping out in of difficulties, promoting the political preferment, obeying the sign, summons, and company. He promptly refused to answer any of them. J.T. Cox, Linnell T. Bush, Samuel Cook, and Luther Blivin were severely called to witness, but stubbornly refused to be sworn to testify, although warned by the court of the consequences of such refusal. And yet these very men have the effrontery to say that Masonry is no way interferes with the administration of civil justice. The plaintiff then called upon Messrs. William Brayton, Benjamin Seeley, and Nathaniel Culliver as witnesses. They gave a full and frank disclosure of the several objectionable points in the Masonic obligation, stated many of the clauses verbatim, and administered in the large room, together with the penalties of some of these obligations. Some of them had sat in large with the defendant and knew him to be a Royal Arch Mason. Some of them recollected distinctly the points of the Royal Arch Oath of keeping the secret, murder, and treason not accepted. By helping out of difficulty, right or wrong, by promoting the political preferment, and all under the no less penalty than having the skull smoked off and the brain exposed to the scorching ray of the sun. The points and the matters, the master's oath, were so fully sustained. It being a late hour at night, the court adjourned till 8 o'clock next morning. The secret brotherhood was such alarmed, and during the night they had much racing and chasing. The purse was made up by the fraternity, and the man dispatched after Leonard Gibbs to help out of the difficulty. Mr. Gibbs entered the arena fresh for the contest, and much to the relief of Mr. Thorne. Mr. Gibbs was a Knight Templar. Mr. Thorne was 1 degree below the entered apprentice. The Sir Knight, alias Lawyer Gibbs, undertook to cover the Masonic favoritism and false swearing by attempting to convince his opponent that the plaintiff and the defendant were equally entitled to Masonic privilege. And Mr. Cone was called to prove the point and went as far to say that the defendants counsel that the succession and expulsion of the plaintiff only excluded him from sitting in the lodge. But when the counsel asked him whether to obey of a sign, summons, or helping out of difficulty in company, did not refer directly or exclusively to a brother or companion of the order. He refused to answer. He was asked if it expelled members to consider as a brother or companion, but he did not like to answer. He was then asked if he was under the same Masonic obligation to the plaintiff as to the defendant, but he did not say. Now mark these facts. Mr. Calvin Cook renounced Masonry, and the Masons, agreeably to their oath, went to work to blast his character, derange his business, destroy his mill, and even threaten to burn his house over his head. And then to hide all this, they with true Masonic effrontery and falsehood undertook to prove, yea, and swear that Masonry only denied him the privilege of sitting in the lodge, though they knew that they were Masonically bound by oath and death penalties to cut his throat in company. But such is Masonry. The document truly said several circumstances transpired during this trial to illustrate the particular nature of the Masonic fraternity and its dread of investigation. Every Mason swore or called as a witness seemed usually anxious to give his opinion that there was nothing wrong in Masonry and that there was nothing in the obligations which he thought ought to disqualify a man from sitting as a juror. And they seemed grieved into the heart that they should not be allowed to crown their opinions, crowd their opinions down the throats of the tiers as indisputable evidence. See, now this is where you gotta, right, that they should not be allowed crown their opinions down the throne as evidence, right? Right here. Okay. Because this is the art, right? This is what's happening when we're talking about Freemason, we should understand what the art is, right? So they should not be allowed to crowd their opinions. See how I was right there like that? This part right there? Their opinions down the throats of the triers and undisputable evidence, right? That's what they do. It's like how you would use the Bible, they'll do this with a dictionary, right? But when called upon to let the tiers have a plain, undisguised fact about Masonry or Masonic oath, they were silent as the grave. While on the other hand, the other witness seemed unwilling to express any opinion, but wished to state the fact and let the tier themselves judge of them. On the second day, Mr. Culver was called as a witness to cross-examine Mr. Gibbs. He was asked, "Did you ever take an oath which you supposed would bias you as a juror?" He replied, "I will tell what oath I did take, and the triers may judge of it themselves. I took an oath of these very words. Here he was stopped by the counsel, who said, "I don't want the oath. I want your opinion whether you suppose the oath would bias you as a juror." Mr. Culver said if the court decided that he should give an opinion to the triers, he would give it with pleasure. Otherwise, he was unwilling to obtrude any opinion upon them, but would state the facts and the points in the oath and let the triers form their own opinion. But Mr. Gibbs argued the question. The counsel for the plaintiff withdrew his objection, and Mr. Culver answered, "I did take an oath which, upon reflection, I was satisfied was designed and directly calculated to set the laws of God and man at defiance." Mr. Gibbs did not ask for a second question when the Masons were on the stand testifying. Such was the agitation of the wounded fraternity that the proceedings were often interrupted with witnesses. The witnesses were told by the spectators not to answer the questions, that the court ought to know better than to suffer such questions to be asked, and that the courts had no authority to make the witness reveal the secrets of Masonry, such as the bold repeat and unlawful interference of John Doty, late sheriff of the county, that he was sharply threatened and punished for contempt of court. He was not alone in this abuse of court. When the challenge was made, the question touching the secret of Masonry was put in a pale foracy seemed visible on the countenance of the members of the institution. Mortally of the most deadly kind sat upon each brow. The counsel in the court were threatened with a speedy ignition of the brotherhood. They grinned horrible vengeance, while their beast of burden groaned and cursed and wept and pitied and cried one to another, "Is there no help for the widow's son?" After the testimony was closed, Mr. Gibbs, on part of the defendant, and Mr. A.E.D. Culver, on the part of the plaintiff, addressed the tears at some length. The case was then submitted under the charge of the court, and after a mature deliberation, the tier returned with decision that Arista's Day was not indifferent. Consequently, Mr. Day was rejected from the jury, being by his Masonic oath disqualified. Such is the way Masonry was dealt with 40 years ago, where honest freemen had the administration of justice, and such is the way it ever will be dealt with whatever honest and intelligible men occupy the seats of justice. No man in senses can accept as a witness, a juror, or a judge. One is one who is known to be bound by oath of death penalties to acquit the guilty, defiant of the laws both of God and nation. And such is the man who is an oath-bound person. And observe this is proved by the testimony of his own lips. In short, till masonry is dealt with as it was at Fort Ange 40 years ago, honest men must still laminate as did Isaiah. Judgment is turned away backwards, and justice standeth as far off, for truth is fallen in the streets, and equity cannot enter. Equity cannot enter. The following from the Lancaster Herald and published in Anti-Masonic Almanac for 1830 deserves a place behind the extracts given above. The heroes of the story being another Masonic lawyer, doubtless as Sir Knight. Griffin's counsel for the defendant. Griffin's remarked that after witness turned was compelled to swear, it might lead to a train of circumstances which would ultimately cause him, Turner, to be indicted for the murder of Morgan. It seemed from statements which we received from a source to be relied on that Griffin, after having been counsel for the kidnappers without compensation during 3 years, began to inquire for his pay. His charges amounting at about $20,000, but could find none to pay. The kidnappers and other Masons who'd employed him to go on and defending them were disposed to excuse themselves from paying, and it seems that some of them denied having ever employed him as counsel. We learned that in reference to this, Griffin said, "Let them make it appear in open court that I have not their counsel, and I will tell a tale which they will not like to hear. I will tell something from which even the limitations of law will not exonerate them, nor will I take any of your small fellows. I will bring next that will grace the halter." The limitation law was evidently of Masonic origin. As I just want to stop for a minute, let you know, this is Old Your Gritty Grand Strains. I'm Juice Warner, as you know, right? This is Old Joe Gritty Grand Strains. Don't forget, we are having a giveaway to the 200 subscriber where you get this free mug and free copy of my novel Street Scalzi, Knock 'em Out the Box. This is just a setup for when I drop my historical book on Freemasonry with the help of these fine gentlemen and many others to bring to the light of this wicked system. Right? Pardon me here. Let me fix my screen so you can see good. All right? I got my tent right here. If you don't know, I'm a grower. Right? So, that's my tent. Got like a good 12 right now running. Where we at here? evidently of Masonic origin. So then, according to his own showing, he deliberately set at defiance and trampled upon the law of God and of his country, defended murderers and trampled upon the innocent, especially the widows and orphans of the murdered Morgan. And for that the space of 3 years, and all this for pay. For if the pay should not come, he threatened to turn on the side of truth. And Mark, with that coolness, he makes the statement as though it never occurred to him that there was anything wrong in all this. Surely such men belong to the number who are past feeling. But this is the very point to which Masonry leads and is denied to lead. That should be the end right there. And did the reset on me? Okay, nah. Okay. So next would be chapter 4. Okay. We'll be back after I take a quick break, quick stretch, and we can get back to catch more wreck. Oh wait, that was my break.